Today, as I told you, our topic is vicarious liability of state. Today we need to understand that in case any government servant, if commits any wrongful act or a tort, whether the government, whether state government or central government, is liable for the wrongful acts committed by a government servant. That is the question we have to address today. Now, in order to understand this, let me explain that law of tort has been developed by the judges. Therefore, it is known as judges made law. It is based on precedents, and we also call that it is a common law, which has been developed through the various judicial pronouncements. And this concept also has had an importance in England. This has been borrowed from England. So therefore, it becomes necessary to look the position in England. In England, it was recognized that king can do no wrong, and there was a legal magazine called Lex Non Protest Picere. King can do no wrong was based on two aspects or two propositions. First, the king has divine rights and immunities, and king commits no wrong. King used to be given certain privileges and immunities, so therefore it was said that king can do no wrong. And the second reason that why king cannot be sued for the wrongful acts either for himself or for his servants was that the courts used to be established by kings, and a king cannot be sued in his own courts. So based on these two aspects, this concept had developed that king can do no wrong. But this proposition changed over a period of time. It was in 1885, Professor A.V. Dicey, he came with the concept of rule of law. And he said that in a rule of law, it is the law which is supreme, and even the king or the queen is also subject to the rule of law. So since then, this concept that king can do no wrong has had a paradigm shift. And there was also a law in England, which is Crown Proceedings Act 1947, which was enacted, and since then the sovereign immunity of the king or the crown has substantially shrinked. So the position in England today is that king can do no wrong is not recognized as of today in a substantial manner, but yeah, some traces of sovereign immunity are found in the law known as Crown Proceedings Act 1947. So now let us look into the situation in India, and we will divide the position that king can do no wrong in three parts. We will look into the ancient medieval India, and then we will look into the colonial period, and then we will look into the post-independent period. Let us look into the position in ancient and medieval India. In India, the king can do no wrong always meant that king has no legal power to do wrong, and king must not do wrong. King is there to do welfare of the people. And in ancient India, there are several examples. For example, Raja Harishchandra and Vikramaditya are known for good governance. Even during the Mughal Empire, certain emperors like Jahangir, they were known for delivering good justice. And according to Manu, it was the duty of the king to uphold the law. Similarly, in Muslim law, the authority of king was subordinate to that of the law. So therefore, if we look into ancient and medieval India, the rule of law always prevailed and king was also subject to the authority of law. But some traces of sovereign immunity were recognized in colonial India. The reason being that we were ruled by English people for many years. So therefore, the concept the king can do no wrong, which prevailed in England, also was to some extent recognized in India, and we have to see how. It was in 1861. There was a authority, Peninsular and Oriental Steam Navigation Company versus Secretary of State for India. This is a case where there was a company and the plaintiff company's servant, they were traveling on a Calcutta highway in a horse carriage, and on the other hand there were government servants who were carrying a heavy piece of iron funnel which they were carrying for repair of a steamer. And that iron funnel negligently, because of the negligence of the government servant, injured one of the horses, and therefore the plaintiff suffered damages, and the plaintiff company, they filed a suit against Secretary of State for India. In this case, the question which arose was that whether Secretary of State was liable for the damage occasioned by the negligence of the government servants or not. The case was decided by 3 judges, with Chief Justice Peacock was heading the jury, and according to him that East India Company was delegated dual functions in India. East India Company was delegated certain sovereign functions through the charter issued by the Queen, and East India Company was also carrying out various commercial activities in India. So according to Chief Justice Peacock, he said that when the act is not in exercise of the sovereign powers, and if a private person can also perform the same activities which is being performed by the East India Company, in that case the sovereign immunity or the maxim king can do no wrong would not be available to the East India Company. But if the East India Company is performing any sovereign function which has been delegated to it by the Queen or by the Crown, and during performance of the sovereign functions, if any wrongful act is committed by the servant of the company, in that case the company would have the sovereign immunity and they cannot be sued for the wrongful act committed by its servants. And this was the first case which was decided in colonial India, and this has been the position till our constitution was enacted. And after enactment of the Constitution of India in 1950, the concept of sovereign immunity had to be relooked because of the various provisions of Constitution. So let us look first of all various provisions which are available in our Constitution one by one. Article 52 of the Constitution of India states that there shall be President of India and he shall be the head of the Union Executive. All the executive powers of the Union shall be vested in the President and shall be exercised by him either directly or through his delegates or subordinates. And Article 74 clause 1 says that the President of India shall exercise his functions in accordance with aid and advice of the Council of Ministers with Prime Minister as its head. And on the other hand, Article 74 clause 2 also provides that the question whether any and if so what advice was tendered by the ministers to the President shall not be inquired into any court. So there are certain immunities are being provided to the president. Oh, and there is another article 361 which provides that the president or governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of the powers and duties of his office, or for any act done by him in the exercise and performance of those powers and duties. So Article 361 provides various privileges and immunities to the presidents, governors and Raj Pramukh in our constitution. But now let us look at the preamble of our constitution. On one hand, we are trying to give immunities and privileges to the heads of the state, and on the other hand, in the preamble we say that we the people of India, having solemnly resolved to constitute India into a sovereign and socialist state. On one hand, we are sovereign, so sovereign immunities are required. On the other hand, we are also socialist, and we also have to look into the social welfare of the people. So if any wrongful act is committed by the state or its servants and it affects or injures the citizen of the country, then there need to be a balance between the sovereignty and the socialism. So keeping all these aspects in mind, today we will discuss the sovereign immunities available to the state one by one.